E quindi vi ridò il buongiorno, una volta avviata la registrazione, vi ridò il benvenuto all'Università degli Studi di Trieste, portando il saluto del direttore e ringraziando l'amministrazione che ci ha consentito di supportare questo evento in condizioni difficili per tutti. Detto questo, I will now move to English for the morning session. So we are on a bilingual workshop, so we will talk in English during the morning and in Italian during the afternoon. Most of us, I think, will be able to understand each other, and so I think that language will not be an issue at all. So first of all, thanks everybody for being here. Literally, I think this is half of a miracle, the fact that we are here under difficult circumstances. Probably for many of us, this is the case for me, it is not the very first event in person again after what we have been experiencing, but it is one of the very first events, and I fear it could be also one of the very last events, like looking forward at the next months and developments. It is a great honor for me to host this conference, and a great pleasure having you here. So first of all, I need to confess immediately, and I need to disclose that I'm not a law and religion scholar in the proper sense. I'm a constitutional lawyer and I'm a public lawyer. And this said, I don't believe that academic boxes are so important for this extent. I introduced myself here in this project as the coordinator of the Jean Monnet module entitled The European Impact on Law and Religion in Italy and Beyond. This is a conference organized and financially supported by the European Union within the program, the Erasmus Plus program, the Jean Monnet module EULERIT, and I'm very happy to specify that, and to specify the fact that this Jean Monnet module was possible and was designed thanks to the availability of many colleagues who are here sitting at this table or connected online and who are involved in this project. So member of the research and teaching team of the Jean Monnet module are Pierluigi Consorti, Vincenzo Pacillo, Diana Zu, Hohenlohe, Mattei Aubel, and Marco Croce. They are all involved in this conference, sitting in this table or connected remotely. So the idea of this Jean Monnet project, Jean Monnet module, is to investigate the impact of the European Union law and of the convention law on the regulation of law and religion in Italy and in some other countries. I have taken up the opportunity to teach ecclesiastical law as an opportunity that was emerged in a contingent way, but then this was a nice challenge from the perspective of a public lawyer in these changing times, with some focus on EU law. Then the opportunity to investigate the crossroad between constitutional law, law and religion, and European law made it even more interesting. I think that law and religion, is at the core crossroad of many legal sectors. So constitutional law, EU law, labor law, criminal law, and these are just like the easiest example. And I know that being a constitutional lawyer teaching ecclesiastical law could be something, unease in some academic circles, but I don't think we are in these circles who are worried because of the fact that constitutional lawyers are taking up this subject field. But I mean, after 1 year of traditional teaching of ecclesiastical law, I have considered the idea of like changing the focus and adopting a European perspective, Europeanizing this teaching. In many cases, I've contacted unknown colleagues who are now known colleagues, and in some cases, good friends. And in the late winter, so we have applied with this project in the late winter of 2020. So it was January 2020 when we got the notification that the project was financed. Then in February and March 2020, we know all what happened. So the design of this module had to face, it was already a challenge, the idea of changing the focus of teaching, and we had to face another challenge. And in some sense, the global pandemic impacted also on our way of approaching this project. We had to fine-tune our seminar series program, our activities, and also, why not, the central focus of our scholarly explorations. It is common wisdom to say that in every crisis there are connected opportunities. I'm not 100% sure that this is true, that in every crisis we have opportunities, but however, we have tried to take the best out of it and to believe that this common wisdom is true. And so we have decided to focus our scholarly attention exactly on the impact of the pandemic crisis on the regulation of law and religion. And this is why we are here. So thank you for having accepted this invitation, for having accepted the challenge to start discussing your own ideas. Before starting the research program, I think that we need to remember and recall a colleague who passed away just yesterday. He was a very prominent colleague in the field of public law, Professor Beniamino Caravita di Rito. I think it's something that impacted many of us, and so I mean, I think it's a moment where we can remember him without too many rhetoric, but just like observing some seconds of silence. So thank you very much. I think that now, I mean, we can go further with our program, and our program opens with the presentation of one of the siblings project that crossed the path of the Jean Monnet module on the European impact of on law and religion in Italy and beyond. And this is the ORFECT network, and Vincenzo Pacillo is the network coordinator, and we have decided to host the first presentation of this network exactly within this project. Please, Vincenzo.
Ladies and gentlemen, it's a great honor for me to officially present the Observatory on Religious Freedom in the Jurisprudence of the European Court of Human Rights, ORFECT. First of all, let me thank Pietro Faraguna and all the colleagues involved in this project. Thanks also to the University of Trieste for this wonderful hospitality and for the chance to give us the room for this short presentation. ORFECT was born as a network of European scholars in legal matters, with the aim of analyzing the cases relating to religious freedom presented before the Strasbourg Court. The Observatory intends to promote a culture of respect for religious freedom, non-discrimination, and equal opportunities. It will organize and manage conferences and seminars, studies, research, and training activities in the field of freedom of thought, conscience, and religion, as well as on the prohibition of discrimination based on religion. As Javier Martinez Torron pointed out, ORFECT is not an isolated initiative in the European panorama, but it adds, with a select group of academics and distinctive characteristics, to other existing initiatives that seek to promote in Europe an effective guarantee of religious freedom. I quote the words of Martinez Torron: "Every effort is made to remind the European institution that it is very important to take religious freedom seriously, because religion and conscience are for many people an essential aspect of their identity." The words of Javier Martinez Torron clearly recall what John Esposito and John Ball called the secularization of international relations. an expression which underlines the crisis of a post-Westphalian model based on the necessity to remove every element of a religious nature from the sphere of the international relations. Globalization, migratory phenomena, and violent radicalism have shown the need to reapproach a transnational politics without ignoring religious beliefs and affiliations. As it is well known, in Western democracies, secularism arises to regulate, limit, or prevent the exercise of certain forms of intervention by believers in public life, a need that is justified on the assumption that the state inspired by democratic constitutionalism is not an ethical state. Both freedom of expression and freedom of religion imply the neutrality of the state and the necessary foundation of legislative production processes on reasonableness of the normative provisions and not on the divine or fideistic origin of the laws. And this also implies that all religious beliefs must be protected by ensuring equality in the enjoyment of fundamental freedoms. At the same time, as Strasbourg Court affirms, public authorities must assure that different visions of the good life can peacefully coexist within the social life. This guarantee is necessary for the protection for the moral freedom of every individual, because it guarantees the exercise of some behaviors that derive directly from the need to comply with the confessional precept. Hence, the first research hypothesis of Horsfeld is that a common definition of secularism requires that the member states of the Council of Europe must maintain a role of neutral and impartial organizers of the coexistence between different religions, cults, and beliefs. Only in this way we can assure that public authorities can fully guarantee public order, religious peace, and tolerance in a democratic society. These are the core values of Horsfeld, and I hope that in the future we can work and operate together for the purpose of these aims. Thank you very much.
Thank you very much, Vincenzo, for the presentation and the availability to connect on this explorations and projects and research projects. So our program continues, and we are perfectly on time with that, with a keynote speech, and the keynote speech will be delivered by the two authors and discussed by one discussant. And so I will leave the floor. We did not discuss what is your internal organization, but I leave the floor to the whole pair, to Javier Martinez Toron from the Complutense University and Maria Valero from the Villanueva University, both from Madrid. But I mean, this is maybe not true for Javier, at least, who is a properly global lawyer. Please.
Grazie, Pietro. Let me begin by thanking Professor Pietro Faraguna for his kind invitation and for setting up this meeting, which I hope is going to be very interesting. And I hope sincerely that you are very wrong with regard to your words, that it will be the last real meeting with real people in the next months. You are normally right in almost everything, but I hope not this time. And thanks also to Professor Vincenzo Pacillo for set the Horsfeld in motion. I think this is like it's one of these initiatives that it raises many interesting questions about how this is going to develop, and I think is going to develop quite well. And let me begin also with some commercials, some advertising about, with Professor Maria Jose Valero and other people, we are organizing in the next September next year, the 6th ICLARS conference in the city of Cordoba, which is a wonderful place, my hometown, what can I say? And 30th of November will be the deadline for presentations of papers, proposal for papers or proposal for panels. And it is just a reminder of those of you who are considering attending the conference, you have a few days to present anything, because I must say that fortunately we are overwhelmed with proposals and we plan to be quite strict with the deadline. So the title I was giving for this presentation was, Can Religious Freedom be Guaranteed in Exceptional Circumstances such as those of a COVID-19 pandemic? The brief response is yes, it can and it must. So with that, I could skip perfectly the rest of my presentation, but I have to justify my presence here and my invitation. And let me offer you a few personal reflections on how the protection, the guarantee of religious freedom is playing out in these uncertain times. I like to think, and I hope I'm not wrong in this, that when we consider these exceptional circumstances, we tend to think of them as something new, something unusual, something that was unpredictable until a few months ago. But I like to think that at the same time, yes, the circumstances are new, but the themes they raise, especially in the area of law and religion, they are the same. They have been there forever. And it basically is how to adapt the protection of a fundamental right to a different set of circumstances. But the themes have not changed, they exist. Because some people tend to think, well, this is totally changing the, well, it's changing the scenario to a certain extent, but not, in my view, to the essence. So I think that COVID-19 gives us the possibility, everything has a positive side. And one of the positive sides, even of a pandemic, is that it gives us the possibility to reflect about what is actually essential in our societies and in the rule of law. We have been using this rule of law, the Stato di diritto, the democratic societies, the respect for fundamental rights, etc. And very often we have been behaving, if I may use this expression, as a sort of a spoiled children. We were used to live in societies in which we had everything. Everything was, we didn't have a war in the West, well, just in some areas in the Balkans, but Europe, if I refer to Europe in particular, we have been for several generations a privileged space in the planet. And that has spoiled many people, many of us, and I would say, it made us accustomed to think that this state of things, we could take it for granted. It may last forever without any effort on our side. And that is very wrong, because the effort is always needed. That took us centuries to be built, and it has to be preserved. So if by the first serious difficulty we experienced since the Second World War, we just started trembling and questioning everything, that wouldn't be a good sign. So we need to, I would say, to keep our minds clear and to focus in what really matters. And when we think of rule of law, probably the two first words that come to my mind is transparency and accountability. So governments must be transparent in their actions and have to be accountable for what they do. That implies not only political accountability, but also legal accountability when that is needed, and to have the possibility of the courts making pronouncement a posteriori about the actions of government, even in these exceptional times in which we got used to grant governments a big latitude, a big discretion about the measures they could take and about the limitation of fundamental rights. We all know, millions of pages published all over these months about the many doubts, the many criticisms that virtually in every corner of the planet, the actions of different governments have raised in mankind. So yes, we needed action, but at the same time, I would say there is a widespread feeling that I cannot see any country in which people have the feeling, oh, how fortunate we were. We had the perfect government that reacted with the perfect action to these awful times. What I see normally is the opposite. So it's a sort of a very, I don't see that this criticism is lacking ground. I think that to a large extent, these criticisms are very, very well grounded. And this idea that many governments feel about themselves, oh, we did what we could. Are you sure of that? So, but I leave that, and it is not the theme of my presentation today. And instead, what I want is to transparency, accountability, and the protection of fundamental rights, because this is a non-negotiable aspect of the rule of law. And that includes the protection of freedom of religion or belief. And freedom of religion is not a disposable thing in times of emergency, in times of crisis. It has to be adjusted. The protection, the guarantee of this fundamental right is in the rest, like in the rest of the fundamental rights. We must adapt it to the circumstances. But the guarantee cannot be discussed, cannot be negotiated. And to some extent, when we see the actions of many governments around the planet, what we see is just the opposite. Is basically the attitude, these are hard times, we will do what we consider convenient for the society we are responsible for. But very often losing the key points of reference in all this. Obviously, when we focus on fundamental rights, the big issue here is the limitations we all have experienced in the exercise of our fundamental rights, not only freedom of religion, of course, but also freedom of religion. And if we concentrate on the paradigm set by the European Convention of Human Rights, we all know that limitation on a fundamental right, limitation on religious freedom, requires three conditions. It has to be prescribed by law, it has to pursue a legitimate aim, and legitimate aim was never questioned. It was public health is a serious legitimate aim, and no doubt public health was at stake here. But it has to be also considered necessary in a democratic society. I will not enter in the area of prescribed by law, but it would be interesting to follow this path also, because a large part of the doubts that have been raised by many scholars around the world refer to the procedures followed by governments in different countries. Like if, were they actually acting in accordance with their respective constitutions or not? We recently have had a very interesting pronouncement by the Spanish Constitutional Court in which they concluded that a part of the action of the government was not protected by the Constitution. It was the procedure followed by our government was not the correct one. And I think that this is going to happen in different countries in the next months. Why governments did act in this way? That's a different question. Probably sometimes it was clumsiness, sometimes it was a lack of prudence, sometimes it was just of lack of request for the expert advice of the people they have at their disposal, but they insisted, I will return to this, in playing this game solo, I mean, without the help of the rest of society. But let's focus on the necessity of the limitations, which is the key point normally. You know, this idea that necessity and proportionality, again, I will not enter this field, but I have the impression that in recent years, also within the European Court of Human Rights, the idea of necessity has been gradually absorbed by the idea of the proportionality judgment. So proportionality was supposed to be something complementary. So like the second step after necessity, first you have to determine that this is, necessity implies, what is necessity? Something is necessary when you don't have any reasonable alternative. If you have an alternative, something is not necessary. Then proportionality comes into the playing field. But my impression is that the European Court is justifying, has been justifying for a number of years, limitations on fundamental rights, including freedom of religion, just according to a proportionality principle. They took for granted that whenever a government decides that something is necessary, the only area in which the court may enter is the idea of proportionality, where the means used for those limitations proportionate, adequate to the goal pursued, etc. But not the very idea of necessity. And I think this, to some extent, we should return to this strict judgment of necessity in due course. Necessity, the judgment of necessity, like the judgment about the proportionality of a measure, and should be a very detailed one. When you want to justify properly that a limitation is necessary, you cannot just be satisfied with generic references to the common good, to the public health, to the protection of the rights and freedom of others. You have to justify why, for which particular rights and freedoms of people, which particular area of public health, you need to use those particular means. That is a judgment about the necessity and about the proportionality. And again, when I examine the panorama of the measures taken by most governments around the planet, what we see is the opposite. They decide with just very general, very solemn statements. We live in very hard times. We have to close files with the government. We have to be united, whatever. But what about the necessity? Why this is necessary? Please explain that to me. If at the same time we realize how often the actions of governments have been contradicting themselves over time. So what was considered to be necessary one week, the next week was not necessary at all, and vice versa. People started questioning, what is going on here? Is this just the pure result of incompetence on the part of our governments? Is there something else? You know, this is something that has emerged in the anti-vaccine movements these days, because when you lose trust in the public authorities, you start questioning virtually everything, because you start asking about which are the actual reasons for that. And then all these conspiranoid theories start emerging in our societies. Do we actually need those vaccines? Or this is just another big move of the big pharmas entering and taking advantage of a terrible situation because they don't have moral scruples for everything. So to some extent, the clumsiness and the incompetence of many governments, or the lack of I would say, the lack of prudence in the measures they take, they end up creating the phantoms of distrust. The area of necessity and the area of proportionality also turns around two elements that for me have been very important. One is the element of the duration of the limitation. So the longer you keep the limitation active, the more justification and the more detailed the justification has to be in order to appreciate the actual necessity of the limitation. It's not the same to impose a limitation of freedom of movement, or freedom of religion, or freedom of expression, or freedom of assembly for 2 weeks than for 2 months or for 2 years. The time factor is important here. And also, together with the time factor, we had to consider the idea of the equal treatment of freedom of religion vis-a-vis other fundamental freedoms. So, and this is something I think that Professor Valero is going to refer to that in her presentation. This has been one of the deciding factors in interesting decisions taken by the Supreme Court of the United States at the end of past year, and by the Supreme Court of Chile at the beginning of this year. The equal treatment is not just we have to justify that something is necessary. If we think this is necessary to impose limitation, for instance, about the number of people that can gather in the same closed space for religious purposes, for worship purposes, we cannot treat them differently in comparison with the people that gather in a different building for commercial purposes, for sport purposes, for education purposes, etc. You have to provide equivalent criteria and reasonable criteria. And also, very linked to the idea of necessity is the judgment of the states, of the governments, about what are to be considered essential services in societies passing through situation of emergency. And you know, this was especially important in the first months of the pandemic, but still they are important today. We are continually masks off, masks on, depending on what is the humor of the government that very week, and which are the figures, and those figures are very malleable sometimes, the figures of the percentages of the infection, the gravity of the situation, the number of the intensive care units, etc. There are so many factors to be considered. But when it comes to what is going to be essential for society, and we deal specifically with the area of religious freedom, the element of the religious neutrality of the state plays a very significant role. The state may make judgments about are there opening hairdresser salons are necessary for society? Are these to be essential services? You know, at the beginning of the pandemic, it created a huge chaos in Spain, like in Brazil. You can close churches, but you cannot close hairdresser salons. I thought that was a kind of confusing thing. I mean, I understand the significance for many people to have a beautiful, but still, we don't have yet a human right to have a hairstyle. But we have a human right to freedom of religion. And instead that was now put at the same level. But again, it is, can the state decide by itself what types of religious services, of religious practices are essential for society? And this is a tricky question, of course, because sometimes people, okay, yes, but religious freedom is not absolute. The religious autonomy of religious communities is not, they don't have an absolute autonomy. Yes, but neither the state has an absolute autonomy of decision in these matters, especially, I would say, in these matters, because if there is something clear in our notion of rule of law, at least in Western, what we normally call the Western countries, I don't know to what extent is politically correct these days to speak still about Western country, or this is kind of cultural colonization or whatever, but still for those of us who believe in the notion of rule of law, the separation, not the separation, but the distinction between the sphere of the religious and the sphere of the secular is a key point. And that implies a certain notion of the state religious neutrality with different nuances. It's not the same religious neutrality in Finland or in Norway that in France or in the United States. But still we have this distinction of spheres. That's important. And therefore, many scholars have pointed out all over the last months that in order to make a judgment about what areas of religious practices could be permitted in times of emergency due to the COVID-19 pandemics, those decisions should be taken in consultation and in dialogue with religious communities. And this, I must say, has been rarely done in any country. In some countries they did, but I think they have been the exception. Certainly not in my country. In my country, like in Portugal, I'm not sure what has going on in Italy, but in my country, like in Portugal, even we have a specific commission for dialogue and cooperation between the state and religious communities, advisory commission on religious freedom. They were not used all over the last months. I know that for a fact in Spain. And when I ask my Portuguese colleagues about that, they say, not to my knowledge. And actually, one of the persons in Portugal that is a member of the Portuguese Commission, he responded very clearly, not, we asked to be consulted. Silence was the response we received. And we decided it's really a moment to act by ourselves. But we had to take the initiative. So this has been one of this unilateralism in the state action has been one of the worst, not the worst, but one of the worst things we have seen these days. And it has been sometimes to confusing situation. It's not the West, at least not in the traditional, but remember the Sri Lankan situation about cremation and all the turmoil it created at a certain point in the international sphere, because the government decided, one, that cremation was absolutely necessary for public health. Well, there was apparently no evidence that was necessary to contain the pandemic. But at the same time, they didn't care, they didn't consult, they didn't consider the implications of cremation for a number of religious communities. And one thing is, you don't need to share the religious community's perspective on a number of issues, but you need to understand what they think, what is important for them. Because otherwise, when you decide which are going to be the necessary measures to contain the pandemic, you may enter, allow me the expression, it's a sort of a Spanish expression, you cannot just enter like an elephant in a Murano shop, just destroying everything because I just want to go my way. You have to consider what you are doing. There are other things in the room, not just the elephant. Another important issue that has emerged all over the past months has been the need for cooperation, I would say, with the civil society at large. But part of the civil society, I would say a very important part of civil society, are religious communities. And again, I'm not sure what has happened in Italy. I have a certain idea. But in most countries, this battle has been fought solo by governments. And one of the, I said, this is not is one of the worst thing that actually has happened for me with the pandemic has not been the deaths of so many people. That's been a terrible tragedy. The worst thing is governments everywhere in the planet playing politics with the pandemic. That for me has been the worst of all. So the governments, all their main effort has been put into not being blamed on the one hand, so that not give room to the opposition parties to take advantage of the pandemic in order to undermine their position, and at the same time, in parallel with that, to present themselves as the only protagonists of the situation and the only actors of the success against the pandemic. We won the pandemic, not society, we, the government, won. That for me has been the worst thing that has happened all over this one. And this has been, I must say, depressing. Cooperation is necessary between the states, and in that regard, many pages have been written about how important the cooperation of religious communities could have been, I mean, actually has been, to fight the pandemic. The problem is that there have been a huge lack of coordination because governments are responsible for coordinating with civil society. And very often, religious communities or religious institutions or religiously inspired NGOs, they had to look for their own ways, because it was impossible to coordinate their action with the governments, and sometimes the government didn't allow them to act with the freedom. Thank you. Then, very telegraphically, the reaction by religious communities, support has been the rule, I would say. The negative reactions of religious communities has been the exception, not the rule. I think that in Italy, the situation has been different, considering in comparison with other countries, because apparently, at least for some months, there were different criteria followed by the Italian Bishops' Conference and by the Vatican. Of those, this duality in Italy is very important. This is one of the characteristics of this country, but you know better about that. And then the vaccination issue, which is on the table. And it makes me sometimes, again, a little furious when they use the word negationist to refer to people refusing to vaccinate, because negationism carries with it a lot of connotation. They refer to a particular moment, terrible moment in our history, to put the same level negationist to the people that refused to accept the existence of the Jewish Holocaust by the Nazis, and use the very same word to people refused. It has a terrible, intentional, subliminal message in that. And I think this is most unfair. It's not I'm vaccinated, so I can speak as one. I'm not a negationist in that regard, but I think this is most unfair, especially considering how these vaccines actually work in different with the traditional vaccinations we have had in the past. So, corollary to finish, two lessons we may learn from this pandemic is, one, we cannot take religion lightly. Religion is part of conscience, is part of the identity of people, and very often we have treated religion in different governments as a hobby or as a hairdressing salons and people, is something accessory to the life of the community, but not very important. Is like if judo lessons is going to your worship place, and actually it's not the same. And the second thing is the need for cooperation. Not only if this is something to be considered always, cooperation between the state and religious communities, in these types of situation, this is particularly important. Thanks for your patience.
Please, Maria, I think you have to use the same microphone.
Sorry. So first of all, I would like to take on Professor Martinez-Torron's words of gratitude towards Professor Faraguna and Professor Pacillo for having me here today and for setting up OPRECT and having me also as part of the team. In the overall keynote presentation that we are doing today, I wanted to focus on the role of courts and of the dichotomy between limitation and suspension of fundamental rights. Picking up right after or from what Professor Martinez-Torron has pointed out during the still ongoing COVID-19 pandemic, it is true that in some parts of the world, freedom of religion and belief seems to have been highly disregarded and treated less as a fundamental liberty and more as a dispensable commodity whose limitation does not seem to merit any particular care or reflection, neither by governments, legislatures, or in some instances, also courts. In unfortunate and extreme scenarios, restrictions on religious freedom have acted as a lever for discriminating, intentionally or not, underrepresented minority and non-conventional belief groups. There is little question that lockdown measures across the planet resulted in not always constitutionally justified limitations of fundamental freedoms, and among them, freedom of religion and freedom of worship. In some instances, entrenched liberties were restricted to a point where it has become legitimate to ask if the so-called limitations were not de facto suspensions of some of their core aspects. Indeed, looking in retrospective at the last 21 months, most mass quarantine and some COVID-19 related health measures have proven to be disproportionate in one way or another. And now that hopefully the crisis has started to ebb, maybe, both national courts and international courts are being called to assess the constitutional and conventional adroitness of legislation and government action. This is not to say that courts have not been involved throughout the pandemic. They have. But I believe that their voice is going to become more relevant as in the months to come, when new waves of the pandemic are going inevitably to clash with the economic side effects of a world that stopped dead on its track for months, with social discontent on how governments are handling allegedly protective measures and vaccination campaigns, and with growing popular skepticism. National high courts and international human rights institutions, such as the European Court of Human Rights, do not have an easy task ahead of them. And in the cacophony of the moment, it is perhaps a good time to take a step back and recall the basic principles of legal reasoning when restriction of entrenched rights are concerned. It's important to remember that when dealing with limitations of fundamental rights, most courts record to one of two doctrines, either proportionality or strict scrutiny, both of them aided by the ever important and overarching principles of neutrality and equality. Proportionality seeks to determine whether restrictive measures are constitutionally or conventionally on par by means of a legal exercise that confronts the state's legitimate objectives against imposed limitations and asks whether the latter were both objectively related to the purported aim and necessary to achieve their intended purpose. The doctrine of strict scrutiny in its turn requires restrictive legislation that affects fundamental constitutional rights to abide by three basic rules: answer to a compelling government interest, a substantial and direct correlation to the promotion of those interests, and minimal impairment. Unfortunately, in the last months, some courts have been, I would say, reluctant to abide by these doctrines to dedicated COVID-19 provisions, also in matters concerning freedom of religion. I was reading a blog post by Professor IP of the University in Hong Kong the other day, and he brought to my attention a decision that hadn't gone unnoticed for me. In May 2020, so quite early on in the pandemic, in South Bay Pentecostal Church versus Newsom, the United States Supreme Court decided to validate California's restrictions on religious services, in-person religious services. One of the concurring opinions, and the judge was citing former jurisprudence, affirmed that since the US Constitution entrusts the safety and the health of the people to the politically accountable officials of the states, when these officials, and I quote, undertake to act in areas fraught with medical and scientific uncertainties, their latitude must be especially broad. When those broad limits are not exceeded, they should not be subjected to second guessing by an unelected federal judiciary which lacks the background, competence, and expertise to assess public health. Now, this sounds very much to me, and take this with a grain of salt, it's just a bit of humor, as, you know, in that lovely old-fashioned and somewhat liturgical English way, in times of crisis, thou shalt not, no, excuse me, thou shalt do what thou think is right and reasonable and will likely not be held accountable. I am positive I've butchered much English, grammar, and law in these sentences, but I think you get what I mean. When strict scrutiny is stopped for second guessing, it is maybe time to pay attention. Mind you, I am not questioning the actual outcome of the decision. I am wondering at the implications that fundamental rights have statements that, read in a certain way, seem to set the tone for a very lenient review of restrictions to entrenched liberties. Acting in a response to an appeal of inconstitutionality in July 2020, the Spanish Constitutional Court did something along these lines as well. The court, as Professor reminded us before, declared that the limitation to freedom of movement in my country during the early stages of the pandemic had been so severe that it could not be deemed a mere limitation, but an actual suspension of this fundamental right, thereby declaring contrary to the Constitution the legal means used by the government to enforce those limitations. However, the court refused even to consider extending the same judicial analysis to other freedoms that were also affected severely during the quarantine, such as freedom of religion and the right to education. And it did so, avoiding any consideration whatsoever on proportionality and necessity of the restrictions. In Spain, as in many other European countries, the Constitution provides for three different scenarios for emergency situations: the state of alarm, the state of exception, and the state of siege. The state of alarm allows for temporary limitations, just limitations of fundamental rights. And both the state of exception and siege permit the also temporal suspension of a numerous clauses of liberties that, let me stress this, do not include any aspect of religious freedom or belief. Therefore, according to the Constitution and relevant norms, in Spain, freedom of religion or belief may be limited during emergencies beyond what constitutional legislation and case law would normally allow under normal and extraordinary situations, but can never be fully suppressed, not even during the more restrictive states of exception or siege. Bear with me for a while. On March 17, 2020, the President of Spain, Pedro Sánchez, enforced a royal decree, which in Spain equates to a formal statute, that placed the country under a state of alarm. And this is a decree that eventually was challenged before the Constitutional Court. Of course, as a means to prevent the spreading of the virus, the decree severely limited freedom of movement and residence. As in many other countries around the world, Spaniards were forced to stay at home week after week until several months passed, only being allowed to be out and about to satisfy what were considered to be basic necessities. No exemption whatsoever was provided for citizens that wished to leave their homes to practice or otherwise manifest their religion individually or collectively. However, freedom of religion was briefly mentioned in the decree in Article 11. The article set in place containment measures in relation to places of worship and civil and religious ceremonies, including funerals. Churches and other places of worship, far from being forcibly closed, were allowed to remain open, and at least on paper, individual and collective attendance was still possible, provided appropriate measures guaranteeing social distancing and proper hygiene were adopted in religious premises. As you can see, this regulation is paradoxical from the outset. Article 11 of the Royal Decree did not limit freedom of religion or worship because it did not suspend religious ceremonies, it did not close churches or prayer sites, and did not forbid individual or collective attendance to religious services. But any external manifestation of religion outside one's home was de facto prohibited, since citizens were not exempted from lockdown for religious reasons. Consequently, the Royal Decree was drafted in such a way that people who left their homes to attend churches and other places of worship could actually be sanctioned by the police, also allowing security forces to interrupt religious ceremonies regardless of whether the premises were complying with these mandatory protective measures. And both the scenarios came to be in Spain. At the end of the day, the severe limitation of freedom of movement during lockdown resulted in a de facto suspension of any religious practice that was not confined to the privacy of the home. I will spare you the technicalities of Spanish constitutional law, but to make a very long and very complicated story short, in a 95 pages judgment that was decided by a tight vote of 6-5, the Constitutional Court dispenses with religious freedom in 2 paragraphs and half a page. The decision is content to quote the generally applicable doctrine that manifestation of religious and worship may be limited in the interest of public order protected by law, and that the notion of public order includes the safeguard of public health. Common ground. Other than that, also common ground. Both freedoms, religion and worship, must be free from coercion, without any reflection on context whatsoever, without any consideration on the proportionality of the measures. The court is content to say that there was no coercion in the fact that churches and houses of prayer were requested to adapt their measures, to adapt their premises to the requirements of the pandemic. And since these measures were both established by law and proportionate, there was no interference with the practice of religion. The judgment also found that there was no constitutional reproach in the fact that lockdown legislation did not provide exemptions to the limitation of freedom of movement for religious purposes, finding no contradiction whatsoever between an article that prohibited citizens under threat of sanction from leaving their homes for any purposes other than the ones specifically stated, and another one 3 paragraphs down that supposedly respected manifestations of religion and worship beyond the privacy of the domestic sphere by not closing down churches. Again, as I did with the American judgment, I pass no judgment on the outcome of the decision, but I am very critical of the legal reasoning, or in this case, lack thereof, used to reach it. Sadly, freedom of religion was treated as little more than a commodity, less worthy of attention than socialization. The Constitutional Court seemed particularly concerned by the fact that by de facto expressing freedom of movement, it had become impossible in Spain to socialize, publicly or privately, with friends and family. But it refused to draw any conclusion on the contradictory nature of the provisions of a decree that rendered the public exercise of individual or collective religious freedom impossible, impinging on aspects of its core content and suspending them. This stance of the Spanish Constitutional Court vis-a-vis freedom of religion or belief is particularly relevant because sooner than later, national pandemic legislation, including vaccine measures, will be subjected to scrutiny before the European Court of Human Rights. Some cases have already slowly but steadily begun to make an appearance in Strasbourg. So far, a few decisions on inadmissibility have avoided a careful proportionality review of restrictions placed on procedural and substantive rights protected by the Convention. Several other applications are still pending concerning limitations on the right to strike, Green Pass legislation, and of course, compulsory vaccination. There is one particular case on freedom of religion that is to some extent similar to the Spanish situation I have presented to you. The application concerns the measures adopted by the Croatian authorities in the context of preventing the spread of the COVID-19 virus. In particular, the relevant authority issued decisions prohibiting to leave the place of domicile and residence except in exceptional circumstances, again like in Spain, and with prior authorization, and prohibiting public gatherings comprising more than 5 people. There was a main difference here because the Croatian religious gatherings were suspended altogether. The applicant in this case alleges that the measures in question breach his right to freedom of religion, freedom of assembly, and freedom of movement. As matters stand, we can only hope that the European Court's tendency to defer to the member states' margin of appreciation in matters concerning Article 9 of the Convention will not lead judges to systematically validate national courts' decisions, such as the Spanish Constitutional Court, to favor contingency and expediency over proportionality and necessity. What the magistrates in Strasbourg, in my opinion, should be hard-pressed to remember is that public health emergencies do not automatically allow governments to suspend constitutional fundamental rights or courts to lower judicial standards when analyzing limitations to freedoms protected by the Convention. As dangerous as this would be at any time, they are particularly so in moments of hardship, which, at the end of the day, serve as stress tests to the health and maturity of our constitutional democratic societies. I am again indebted to Professor Ip for, after so many years, giving me the source of a quote that I had when I was much younger and I was a law student in Madrid. And I have often used this quote with my students myself. In 1924, the English Chief Justice Lord Heward said in the famous case of R versus Sussex Justices ex parte McCarthy that not only must justice be done, it must be seen to be done. In a time of a global pandemic, justice is done and seen to be done when magistrates accept the responsibility to become the last standing fortress for the protection of entrenched rights, but not eschewing, as I have said before, proportionality and necessity for contingency and expediency. Thank you very much.
Thank you very much, both Javier and Maria. And now the floor is for Pierluigi Consolti for his comments.
Thank you very much. Good morning to all. And how many time I have? Because I don't want to waste our time more than 50. So because we can also have to answer to the question of this morning. That is, can religious freedom be guaranteed in exceptional circumstances? And the answer is at all yes. But not only if it is possible, I think that it is a necessity. So I want to outline 5 points, and I thanks very much Professor Javier Martinez Torno because he sent me a draft of his speech, and I can give you some ideas. These are my personal ideas, but I want to mention the work that we have had with the DIRESOM Italian Research Group. This is law and DIRESOM is diritto e religione nelle società multiculturali, law and religion in multicultural societies. This is a national group that had the opportunity to follow the pandemic situation, I can say, since the beginning on the March 2020. So the first point is something that is also the beginning of the reflection of Professor Javier. We experienced a real and serious fear. These are special circumstances of this emergency that are in the background, but it's not only the background because it comes immediately on the scenario. What happened? The first thing is that we experienced the lack of scientific acknowledgements about coronavirus. And in many states, there was also, and there is also now, a lack of a so-called legge quadro, framework law, lei organica, related to the emergency. Not everywhere, for example, in Germany, there is something around this, but it means that we have no specific point to know what it would be possible to do in this circumstance. It's a special circumstance because it's not only an emergency, but it is a health emergency. We experienced it a lot of years ago, as you remember, no? At the beginning of the last century, and it is not possible to compare the law of the last century with the law, and I say not only the law, but also the principles of law that were in that period and now we have. The law is a social issue. It's not only a system of law. And we experience this, this is a, I can say, a reality that we as a scholar of law often forget. We think about law as a system that have to function in a right way, and we don't want that there are, so I would say we are also we are not so passionate when we see that the politics that are the making of law do some mistakes. But we have to, this is for me in this situation very important, to understand that since the law is also a social issue, is a social point of our life, fear is very important, anxiety is very important, haste was very important, and probably is now actually important. And we have experienced the need of a rush without knowing the health. So let me give you an example. I don't know if you have experience with rugby, but we have in a rugby moment. In a rugby moment, there is a schema that you have to proceed all together without jacks forwards, because they are not a good idea. And we experience this. And it is not so simple, because we do not love to work in team. And this is not only a problem of a single nation, no, but we have a worldwide problem. And it is, I think, very important also for our experience now, not only the national law, but the European law, but we have no European law related to these issues. So we had not the possibility to have a common work related to law, to rules. We experienced the necessity to proceed everyone alone. We can cooperate, for example, to buy vaccines, but we have okay. The second thing is the importance of fundamental rights protection. I agree with this. And what is this? What it means? We have now fundamental rights protection as an hard issue, and it was not before. You told about the experience of barbershop and churches, no? The peluqueria questions. It means, and this is the third question, that we experience the need to balance different and not oppositive issues that are all fundamental rights, with different fundamental rights. Maria, remember the impossibility to go out of our houses. It means we cannot do anything. So other different possibilities were I would say it is not only the problem of we cannot go in churches. And this is the necessity to balance public and personal health and public and personal economy. So I think that also this one is another, let's say, contemporary issue. Because when we have the goal as a goal to balance economy and fundamental rights, we do not have the same points in the same balance. Economy is not a fundamental right. Four, the power of public institution versus the proportionality of the restrictions. And as Javier pointed out, for us as scholar of law, it means we have to face with the procedures and substances. I say 3 points. The first one is the distribution of competencies. In Italy, for example, the state competencies versus the regional competencies, especially in health matter. But we can also say, the states is not always the same, but there is the same problem. And it is also at the European level, which are the competencies of European Union in this moment. The second is the sources of law, because the rules of emergency created, I can say, special law. this is a social consequence of the anxiety, fear, and what we have already said. But normally, it's not so simple to put this source of law in the normal scheme, for example, of the hierarchy of law. I don't know, as out in Spain for these royal decrees, but in Italy, also in the constitutional scholars, let me say that we have a larger box, because the box in Italy is constitutional and ecclesiastical law, so with the same box in the larger box. I can say there is a problem because we face it to this DPCM, a decree of the President of the Council of Ministers, and a lot of people say these are not good to change the law. But this is not real because the law in Italy, the only thing that we say, the law of emergency, says that in emergency it is possible to have special decree that can give exception also by the law, but not against, they cannot go against the principle of law. But principle of law, this sentence, is not so simple to understand. But the limits are not the same, the limits of the law. So relating to this issue, I can say that the name are decree, but the substance is law. And then the third point is which kind of judicial control. Normally we give our attention to the, as it is correct to do, at the Supreme Court, the Spanish one or the German one, but we know that there are a lot of also of, I can say, lower judges that face to these situations, really, because of this uncertainty of the kind of these rules. Then I arrive at the fifth and the last point, that our more specific areas. So one, the position of the religions, the religious freedom among fundamental rights, and then the cooperation between state and religious community. The position of religious freedom among fundamental rights, in my opinion, is the same position of all other fundamental rights. It is a specific area, but it must not be a privileged one. As I have already said, the states have the duty to protect fundamental rights as well as the rights of religion, but have the duty to save the life, and so if it is necessary, also the religious freedom can be limited, probably also suspended. That is it's not so a clear distinction, but in my opinion, for example, we experienced the limitation of religious freedom, but only related to the specific position of this religious freedom. It has the limitation of the collective calls, not religious freedom. That is the core, not the religious of conscience, not the religious of belief. And it is possible because it has been possible because there was another good to protect. The cooperation between state and religious and the religious community is a specificity that is to the role of religion and also to its social meaning. For example, not only spirituality, but also social care. I think that it is the most important challenge that we have to deal with in the future. Religious communities are autonomies, But we have not to forget the principle of laicità. I have to say in Italian, laicità. But we can say the secular principle, but it's not the same. Eh? But okay, the laicity. So that there is a difference between the state and religious bodies. And we must pay attention to this difference. That is a principle. It's not only some that we need to in the moment that we have to apply. And I think that the dialogical perspective that also Javier mentioned is that this dialogical perspective that, as we all well know, is different in our European Union states and also at the European level. But I think that we can have an important ground by the European law, and especially in the Article 17 of the Treaty of the Functioning of the EU, that, as you all well know, reclaim an open, transparent, and regular dialogue between the EU institution and churches, religious associations, and philosophical and non-confessional organizations. So it means something more than the normal relationship between states and churches that we experienced in the last years in Italy, in Spain, in Germany. No? So it's the possibility to have relations between the state and the, I can say, institutionalized churches. We, in a social perspective, we have not only more the churches, but in Italy we now use the expression community of faith. That is not so simple to translate, but it's a community of faith to say that not the same as confessioni religiose. When Marco Ventura wrote his book in English, I remember how may I translate confessioni religiose? That is the expression that we have in our constitution, but it's not translated. It's not simple to translate because it is not only they are not only words, but it's a concept. Which is now this concept? So, for example, in my opinion, we have to understand that it is not only a specific religious problem related to churches and religious association, but also for philosophical association. For example, you remember the question, the churches are open and the theaters are closed. And now, for example, now in Italy, we have to go to theaters with Green Pass, but in the churches without Green Pass. So this is a problem that you also relate. But I want to conclude, remember an important experience that we had in Italy in May 2020 related to this dialogue. I can say dialogue is the future. But we have to understand for the future, and this is also a lesson that we learned from the pandemic emergency, that the schema that we use to have a relationship between state and churches that is good for an ordinary time, it doesn't work in extraordinary times. The Catholic Church was able to use its influence, that is not a social influence, but is an institutional influence, and had the possibility to arrange a dialogue with the Italian government, but it was not possible for other religious communities. On one hand, those who have an agreement with the state, and on the other hand, those who have not this agreement. But they, the first, the Catholic Church, the second, those who have the agreement, the third, those who have not the agreement, have the same problems and the same needs faced to the state. It's not only faced to the government, I can say faced to the society. How we can continue to express our faith also in a collective way during this emergency. And the first step was to agree all together that the position, the good position is the first point is the public and personal health, then the possibility to stay together, to live together. Because not all religious groups agree with this position. Because they say, for example, as you know, in the churches, virus cannot enter because we have the divine protection. And this is a position that already now we have. No? So I read this morning, the president of Italian bishop said, priests that do not want to vaccine, they can do this, and they can also speak against vaccine because they are not obliged to be vaccinated. But it's a confusion of two levels, no? The levels of the opportunity and the levels of duty. So the experience in Italian was that the Ministry of Interior had a virtual assembly of all faiths, community of faiths. The only absent was the Catholic Church. And this was the possibility to have a transparent dialogue. And now it is not regular, but it was transparent, that give the possibility to arrange a special protocol is the name, so I can say for some guidelines that give the possibility to churches and community of faith to have their collective expression of faith during pandemic, and this is a good opportunity that we can use also for the future. I can say from the crisis also an opportunity, a different way to have relationship between states and religious communities. Thank you.
Thank you very much. So I think that this triangular debate with these three talks is giving us amazingly inspiring thoughts and food for thought. So now we have two options. Either we could open the floor and start a discussion that would lead us until the end of the day, or we can decide that, I mean, in the design, this introductory triangular debate, is what we need to start going into the 7 papers we have to discuss. And so I think that, because of the overall circumstances, I will not open the debate now, and I will, without hesitation, pass to the panel. We are running late, but we have a magic bullet because we are not so late as in the first panel. We will have only Maksymilian presenting because of Adrian Rubio didn't make it to join us, and so this would unintentionally save us time, and so I passed the chair. I virtually stepped down from the chair role to my colleague Fabio Spitaleri, professor of EU law at the University of Trieste. He has a very, very tough task, and this task is bringing us at the coffee break at 11 o'clock, let's say 11:05. But the idea is that, we have circulated the papers, and so we have agreed with authors that we would like to focus on the debate more than on papers that we have already received, and we have designated discussants for that. Fabio, the floor is yours.
The good news is that the task is possible. Of course, I ask for the cooperation of our speaker and discussant. And the time limits indicated by Pietro are 10 minutes for the discussant, for the speaker. We will now open the first panel of the conference dedicated to the theoretical perspective. On this first panel, we have one speaker, Dr. Maksymilian from the University of Warsaw, and two discussants, Professor Diana Zhu Hohenlohe, that is connected online. Professor Zhu Hohenlohe. Yes. Welcome, Professor, and thanks for being here connected on Teams. And the second discussant is Professor Vincenzo Pacillo from the University of Modena and Reggio Emilia. This panel aims at examining the theoretical aspect of the impact of the pandemic on religious freedom. Legal systems have offered distinct legal responses to the pandemic emergency, ranging from a complete suspension of the collective exercise of religious worship to a more cautious accommodation of religious gatherings. I would like just to emphasize 2 points. The first is that the different religions have specific characteristics which prevent a unified approach in identifying the restriction on freedom of worship that are necessary to deal with the pandemic. The second point concerns the need for a close dialogue between public authorities and religious denomination or a faith group to identify this restriction, balancing the protection of public health on the one hand and the freedom of religion on the other. So, having said that, I shall immediately give the floor to Dr. Maksymilian, PhD student at the University of Warsaw. The title of his report is COVID-19 Restriction on Religious Worship, How to Ensure Effectiveness while Respecting Religious Autonomy. Dr. Rao, you have the floor.
Okay, thank you. Does it work properly? Yeah. Okay, perfect. Well, maybe like this would be better. So before I start, I would like to express my gratitude to all the organizers of this great event, especially to Professor Faraguna, and thank you all for having me here. I will try to be quick. So the topic of my presentation is COVID-19 restriction on religious worship, how to ensure effectiveness while respecting religious autonomy. The idea I would like to share with you is that restriction related to the capacity of church premises, which are the most popular, should be replaced with ones focusing on kinds of activities carried out therein. The spirit, let's say, of my presentation corresponds with what Professor Martinez Torro remarks on the need for more transparency and cooperation with religious association from the state, with which I do completely agree. So, firstly, I will demonstrate that restrictions preventing spread of coronavirus, which focus on church premises, on capacity of church premises only, which I call premises-oriented, cannot be maintained anymore since they are not proportional anymore. Secondly, proportional and effective anymore. Secondly, I would like to show how the new suitable for the current pandemic situation restrictions should look like. The main idea is, as I said before, that they should be focused on rather kind of worship activities carried out in the church premises. And in the third part, I will show advantages of this kind of limitation called activities-oriented and show how they stand in relation with religious association autonomy principle. So as we all know, during pandemic in most European countries, but also in the United States, for example, the number of people who could gather together at the same time in religious premises was limited for various forms. Like, for example, the maximum number of people who could gather was fixed and explicitly mentioned in the legislation, or the maximum number of people who could gather needed to be calculated in accordance with the legislation which specified the ratio of people per square meters, etc. Such restrictions, the premises-oriented restrictions, raise at least two kinds of objections. And one of them has to do with the epidemiological effectiveness of those kind of restrictions. Do they successfully prevent transmission of COVID-19? And a second objection is connected with the question how to determine whether the number of people allowed to gather is still proportionate. In other words, what are the reasons for picking the certain number by the legislator? Natural response would be that such a number should be mainly determined on the basis of a scientific knowledge about the coronavirus transmission be as high as is possible. It must be kept in mind that when the answer to the first doubt, the effectiveness doubt, is negative, then the same must be for the second one, proportional one objection. My thesis is that ineffective restrictions are not proportional because the effectiveness is significantly lower than the burden of constraint imposed, and as a result must be considered to be in breach of religious freedom. The examples of Portugal, where restrictions on religious freedom stayed in force even though the state of emergency was over, or Poland, when in Easter 2020, the limit of people allowed to gather in church premises was down to 5, which basically was equal to closure of church premises, show how far-reaching the premises-oriented restrictions are or can be in any time. And in addition, the epidemiological effectiveness of premises-oriented restriction is highly questionable. Scientific researchers show that coronavirus is transmitted mainly through small respiratory droplets, and activities other than breathing, such as speaking, as what I do now, coughing and sneezing, impact the rate of spreading rate of droplets, and in consequence, risk of COVID-19 transmission. So from this point of view, focusing in process of designing the restriction on the occupancy of church premises is less important than focusing on activities carried out therein. Taking the above into account, I agree with the US Supreme Court Judge Alito, who observed that, I will cite it, as more medical and scientific evidence become available and the states have time to craft policies in the light of that evidence, courts should expect policies that more carefully account for constitutional rights. So premises-oriented restrictions place burden on religious freedom and are not effective in preventing the spread of COVID-19. Being so, they are not proportional, and this fact stands for reason for implementing new kind of restriction. But how those new kind of restrictions should look like? On the one hand, they should reflect the current pandemic situation, like including like growing vaccination level, and on the other hand, they should be consistent with the current scientific knowledge about the coronavirus transmission. The idea is that religious associations should be able to communicate to the appropriate sanitary states bodies how they are ready to change their practice and rituals to minimize the risk of coronavirus spreading while enjoying freedom of worship. The religious associations, of course, are the only entities that know best which aspects of worship can be changed or replaced without affecting the operation of religious services. The role of the government in this process should be only to review the religious association proposals primarily in the scope of their epidemiological effectiveness. And I think that this possibility of proposing changes to the liturgy, let's say, to fit the restrictions should be voluntary opt-out mechanism. And research showed that on the example of Roman Catholic liturgy, that permissible elements of liturgy like reduced verbal participation of the part of congregation, singing only by design choir, ad orientem position, etc., are on the one hand perfectly valid with the Roman Catholic liturgy rules, and also they carry much less risk of COVID-19 transmission simultaneously. And what is also very important, practice proves the value of this way of thinking about the restrictions. UK government issued non-binding guidance encouraging religious associations to modify its worship activities to minimize the spread of COVID-19 by modifying the worship activities. In Poland, some religious association asked the general sanitary inspector whether its changes in liturgy minimize the transmission risk, even though the law did not provide for such possibility, which is another example of what Professor Martinez Torres said, how religious associations are open for cooperation in these hard times. In Italy, the special protocols regarding the organization of religious gatherings in the state of epidemic have been signed with various religious denominations. These documents are particularly interesting. In most part, the protocols contain general safety provision, but each protocol, section 2, is devoted to essential and possible changes to religious practices and rituals, and it varies accordingly to the specific practices and rituals of each religious association. So as an example, according to the protocol signed with the Jewish community, only one cantor could be present during a religious event. Whereas according to the protocol signed with the Protestant churches, a special sanitary regime must be applied during delivering the Lord's Supper. And this kind of activities, as I said before, I call the activities-oriented one. So what are the pros and cons of the activities-oriented restrictions? The epidemiological effectiveness is, of course, the strong advantages. If certain activities significantly rise the risk of transmission, then eliminating them or limiting them or changing them is the best way to prevent of spread the coronavirus. Another important practical advantages is that activities-oriented restrictions allow for enjoying the collective religious freedom in a scale more or less similar to those before pandemic, but definitely far more better than premises-oriented restrictions. And of course, the legal aspect cannot be dismissed. If the premises-oriented restrictions are not proportional or can be seen as not proportional anymore, there must be replaced by the proportionate one anyway. And the other advantages of the activities-oriented restrictions is that they are more transparent, to which Professor Martinez Torres drew attention, because the logic behind imposing them is quite clear, I guess. Of course, the important doubt might be raised with respect to ensuring the religious association autonomy principle. The sphere of defining practices and rituals of religious association, of course, belongs to the same catalog as defining the religious doctrine, and consequently is exempt from state intervention. So in result, activities-oriented limitation cannot be imposed without being previously agreed with religious association, because otherwise, of course, they are likely to violate the principle of autonomy. But scholars point out that religious association had a positive and cooperative attitude toward the obligation to limit or even temporarily suspend religious gatherings. They were ready to change to some degree the important elements of worship, but not to suspend it also, which shows also that they would be, of course, they would be more ready to participate in designing the activities-oriented restrictions, which allow them to operate, than to premises-oriented restrictions, which do not allow to operate them, more or less all. So given that, I see that there are great chances for introduce this activities-oriented restriction, taking into account those cooperative attitude. So lastly, it should be kept in mind that COVID-19 restrictions are not a one-time event. Unfortunately, of course, another pandemic might strike again. But anyway, it is important to develop model of restriction, which not only be effective in preventing spread of coronavirus or any other similar things that may happen somewhere in the future, but also would contribute, and this is important, to more general model of better cooperation, maybe more closer cooperation between the state and religious association, which will stay with us even when the COVID-19 is gone. Thank you.
Thank you, Dr. Rao, for your brilliant presentation. It seemed to me that you have highlighted well, very well, why the specific characteristic of religion require a differentiated approach. So I will now leave the floor to Professor Diana Zhu Hohenlohe. She's a professor of public and international law at the Sigmund Freud University in Vienna. Thank you for being here connected, Professor Zhu Hohenlohe. You have the floor.
Thank you very much.
10 minutes, Professor. 10 minutes.
I think I only need 5.
Oh, perfect.
To be in time. Thank you very much, Maksymilian, for this wonderful presentation. You showed us very clearly how complex the phenomenon of religion is. And you also showed us very nice how human rights have to be balanced between each other. So I only want to focus on 3 points. The first point is the question whether religion is not predominantly a collective phenomenon. So can religion not primarily be executed, it has to be executed in a setting where you find more than one person? Or can this only be thought can it also be thought in a situation where you have only one person? If religion is predominantly a collective phenomenon, then you always need the other to execute your religion. And that has often been neglected by governments, which think that giving the main guarantee means granting freedom of faith, and that means a freedom in your head, so you are allowed to pray in your private home. But is not the main core of religion to meet with others, to do worship together? We are speaking about religious communities in which religion takes place. So, and this means that every kind of restriction regarding meeting with other people always is also an infringement into core aspects of freedom of religion. So that should not be neglected. So this means in such a state of emergency like the COVID pandemic, freedom of religion is one of the most vulnerable rights in society. That is my first aspect. The second aspect is, and in fact, Maksymilian also has mentioned it, that it should be separated or made a distinction between central aspects of religious worship and not so central aspects of religious worship. We are coming into our normal balancing scheme. If you have a basic right, it's maybe so big, you have core fields of the basic rights, then you have more middle fields, and you have a central core of the basic rights. And it should make a difference whether you infringe at the outer parts of freedom of religion or the core of freedom of religion. And this can be different between various religious communities. So in one community, maybe the Mass is very important. You should come together and take the hostia, the bread, and celebrate it with that others. In this religion, maybe this aspect may be in the core. And this means if you prohibit coming together and going to churches, it can be a very intensive infringement in this freedom of religion. On the other side, you may have other religions. Take, for instance, Jehovah's Witnesses. There it may be at the core of the religion to go preaching from one house to the other. And if you then prohibit to go preaching from one house to the other, it can be at the core of this religion. And therefore we have a very difficult system, since a state measure can, in regard of one religion, infringe to the core of the religion, and for the other religion, it can be only at the outer spheres of this religion. And we also know that who decides about what is the core of a religion or what are the outer fields of a religion? That is a self-determination by that religious community. And therefore, it's essential what Javier and Maria and all the others had said, that the dialogue is necessary to find out which restriction goes how far in freedom of religion of this religious group. And this had been also made very clear by Maksymilian, that paying attention to self-determination and autonomy of these special religious groups is very essential. And it has also been mentioned that Article 17 of the Treaty of the Functioning of the European Union, the former Article 11 to the Nice Treaty, is very essential, and the dialogue should not be neglected. And as regards to Germany, I should also say, or Austria, there is not much dialogue. What we see is that the religious communities by themselves restrict their activities to what they can see. On the others, and my third point is, and this also focuses and in fact says it was good what Maksymilian said about that, the activities-oriented restrictions. Having in fact a look what is done. Singing may be very dangerous, since then viruses are spread. So maybe the religious communities should limit only singings, but can sit with FFP2 mask in the mess. On the other side, something done outside, a funeral in a forest, that can be not dangerous since it's outside in the air. Why limit there the numbers? If it's important for that religious communities that, or even an essential sacrament, doing a funeral in this religious group. So in fact, saying that if you going to a funeral is the same than going to a demonstration, that is not the same thing. So I have also the point that maybe religion is in fact a special thing. And maybe in fact, freedom of religion is not maybe on the same level than freedom of profession, of freedom to move through the country, Freizügigkeit. Maybe it's in fact not true that freedom of religion has the same weight in balancing procedures than freedom of profession. Maybe even if you look at the jurisdiction of European Court of Justice, freedom of economy, maybe this is a right in the EU context, as we have seen in the Burqa cases. So it's in fact that we have a careful look and to pay attention that there are various forms of religious activities in different religious groups. So again, I thank you for all the good impetus I got today from all the speakers. I'm very happy to be among you, and thank you very much.
Thank you, Professor Hohenlohe, and I leave immediately the floor to Professor Vincenzo Pacillo. He's a full professor of ecclesiastical and canon law at the University of Reggio Emilia and Modena. Please, you have the floor.
Thanks, Mr. President. Mr. Chairman, I will try to be as clever as my colleague Hohenlohe was. I try to underline 3 points. First of all, thanks to Maksymilian for his excellent presentation. I think that I try to focus on 3 points from your presentation. The first one, I seem that you try to point out the necessity to have clear, precise, and up-to-date state interventions in order to rule the public's exercise of worship in these times. Well, if I think to the Italian situation, I feel myself a little bit scared about this, in the sense that the situation is not clear in Italy. The protocols that Pierluigi Consorti mentioned some minutes ago, adopted after the intervention and built on the observations of the National Scientific Committee, became a sort of yardstick for the legitimate exercise of the government's discretion in the face of the need to operate a correct balance between the right to health and religious freedom. So from this point of view, these protocols are an instrument of crucial importance to fully implement bilateralism, but also to safeguard the health of faithful during the religious ceremonies. But I ask myself whether the protocols signed in May 2020 and amended in July 2020, with the curve of infection and deaths that were rapidly and evidently decreasing at that moment, could be adaptable to the epidemic situation, for example, of November 2020, that was characterized by a record number of new infected and new deaths, unfortunately. I ask myself once again if the situation that was planned in Italy in May and in July 2020 is something that can be adapted to the situation of nowadays, in which we have a sort of pass to accede some closed places, and that's not useful for the churches, but in the same time in which the situation of the pandemic completely changed its face because of the vaccination process. I ask myself once again whether it would not have been more appropriate to create a government control room in which the Consultative Commission on Religious Freedom, we have a Consultative Commission on Religious Freedom in Italy, but it's awaiting a reconstitution from the year 2018, could have played a key role in this process. I ask myself whether decisions such as the decision to celebrate the first communions in a public form, which occurred in many parishes of the Diocese of Milan between 7 and 8 November 2020, should really be left to the prudent appreciation of the priests and faithful, and not rather the decision of an apical process of consultation between the government and the episcopal conferences. These are the first point. The second point, it was very impressive to me, the part in which you discuss on the impact of the rituals, on the rituals of the governmental choices. My question related to Italy and to the Catholic Church is, did the really protocols change the right? Well, honestly, nowadays the pass is not required for going to the mass or joining in processions. People are going to the mass, but they must wear a mask. Pews or chairs must be spaced at least 3 feet apart. The faithful may receive communion only in the hand, and there should not be no shaking hands at the sign of the peace. But for example, one of the most impressive issues that has been, in my opinion, very underrated by the scientific, the academic world, is the question of singing during the ceremonies. It was clear, according to St. Augustine, that who sings pray twice. And this perspective is quite strange because, for example, it was very, very underlined in Ireland, in which the congregation of Protestant churches are very scared about what will happen in Christmas, because you know that the Christmas ceremonies for the Protestant church are very linked to the Christmas carols, to the singing in the church. But honestly, from my experience, the problem is also, for example, in the Italian situation, in which there are some guidelines more or less clearly expressed in the protocols, but no one controls what happens really. So everything is managed by the freedom of the priest, of the community, and this situation could create some problem, especially in peculiar times of pandemic. My last remark, honestly, we have to say that no major religions has come out in opposition to the COVID-19 vaccinations. Jehovah's Witnesses, Christian Scientists, Catholic Church have all issued statements saying that their religion does not prohibit members from receiving the COVID-19 vaccine. The Pope has declared getting vaccinated is an act of love. But from another side, as my colleague Hohenlohe pointed out, there's no way to judge if the religious perceptions and the religious argumentations made up by an individual who does not want to receive the vaccination could be judged as genuine or not, sincere or not. Honestly, In Europe, we have a legal basis for employers to assess sincerely held religious belief. If I think about the Arsmith case or the Veda case, we have to ask ourselves whether the employee's behavior is inconsistent with the professed belief. The accommodation constitutes a desirable belief likely to be sought for secular reasons. The timing of requests renders it suspect, or the employer has an objective reason to believe the accommodation is not sought for religious reasons. But I have another problem with this issue. Very recently, a senior Vatican figure, Monsignor Viganò, has publicly declared that COVID-19 does not exist. And the media had covered up systematic lies about its existence, and the vaccination against the virus are the work of Satan. Well, honestly, I ask myself if we are in front of freedom of expression, in this case, granted by Article 10 of the European Convention, or we are in front of the Article 17 of the European Convention of Human Rights concerning the abuse of rights. This is, I think, a very important point, because even in this kind of responsibility towards the health of the people, religious authorities cannot exceed the limitation made up by the European Convention, and even the use of the Article 17 in this case could be very important. Thank you very much.
Thank you, Professor Pacillo. I think we have not time for a debate, but perhaps a few minutes for a brief reply by Dr. Au. You have the floor, Dr. Au.
Okay, so I would like to start with saying thank you for all the remarks. Maybe I will just try to answer to two remarks, but maybe not and answer them. I'm thinking, of course, there is maybe the main problems. Once we will have a good idea how the restrictions should like, of course, is the way how to control whether they are exercised. And well, I don't have an idea now how to do it properly, but my first thoughts, of course, are the I don't know, maybe administration penalties are okay in case the religious association have some would be able to take part in designing the restrictions. But that's why I also propose this opt-out mechanism, because it allows allows the state to go back to this wrong, maybe not proportional, but in case other ones are open, they are maybe proportional, the premises-oriented restrictions. So if what the religious association proposed is not effective, or if religious association disobeyed to what they promised to obey, maybe state should be able to cancel this privilege and go back to this more tough premises-oriented restrictions. And the second thing, of course, is connected with the thing you said about the protocols signed in June do not work anymore in December or any other month. And of course, that's true. And that's why religious association and state should cooperate in a way of making more scenarios for future circumstances, which I guess is possible in the current state of pandemic. We know more or less what can happen in the future. We know more or less, well, this is a delicate question, how the vaccination, what are the results of vaccination, how the vaccines work, etc. So I agree with you, with all of you, that there is a need to establish some committee which is ongoing, and it keeps ongoing dialogue with the state, and this there's a need of this kind of legal framework for cooperation. And I guess that's all. Thank you very much once again for the remarks.
Thank you, Dr. Rao. I think the panel highlight some key points, differentiated approach, dialogue between public authorities, and the respect of the core of the freedom religious. I think the key point, the fundamental issue is the level of the scrutiny in case of litigation before a court. In my opinion, it's difficult to say that the scrutiny has to be strict in a context of pandemic. However, I conclude this panel by thanking once again Professor Faraguna, our speaker, our discussant, and all of those present here in the conference room or connected on Team. Thanks again.
Just for the housekeeping information, we will have a coffee break. That it is something that it is distinguishing clearly a virtual conference from an on-site conference, and it will be on the terrace. So when we will come back, it will seem to be warmer inside, probably.
Yeah.
See you at 11:30, also for people connected online.